So, a tribunal bill say Attorney General Adikoko PMU ewo Parliament no abusuya NPP minority at the home assembly ebetuja omo say bill yi pa tribunal bill special court say NDC government the Attorney General epese osanso de bana omo de fast track case no abusuya omo de omo asema na omo ka say enya ade a omo beti ase na eye ade a NDC government no ede ba be hante eye omo NPP for no and a top NDC lawyer ababonten den sembi ababetuja o say NPP for ya omo say special court in tribunal ya Attorney General any NDC debay eye ade papa na omo NDC ono as NDC lawyer no sa special court no ono wa endorse say fear ya NPP for eka say we na tribunal court is NDC for the bar omo de be hanti NPP criminals no eye ade a ebe course ehu bi ede ahye amanfo ni mu ni ade o say enya no kreda o say enya no kre na sa tribunal court enye ne ena ye ba beti sa tribunal court eya dia e ba be boa oman no and osanso e the warning bi ema NPP criminal appointees omo abokro no abusu asa lawyer yi ashoke NPP criminal appointees ene NPP fo a omo se omo nte ase ema yem pass sa bill no abusu enti no NDC top lawyer wa endorse no an amawasanso approve the special tribunal bill and as a court the Attorney General edeba NPP for kase omode ebe cause fear or say enye fear bia and ebe cause na unim say umbo or minor chrono and as a on cause any financial loss to the state sa tribunal court no or the any kwanse order now odwumo me yanko na yenkonkoti ensema e cause no ye ba ye de aka to am na asa na ebe kono Ghana ha say open computer papa and a laptop papa na we using a Burra Perosi computers and accessories ho and a obenya laptop papa na we using the location and yira kwan o Kumasi Bukrom Estates Eli Peke number na eguye screen yasi na Efre Perosi computers na ade ba kwa ede wo mni say ukra low budget and as a high budget open mount high quality laptop na we using Burra yensem ne ba ya de aka atwam so
of the process for appointment. I think all of that, the questions you asked are in the bill. So I'll share a copy of the bill with you. Yes.
Because my learned senior has raised certain important matters, I think it's important that I intervene quickly to put the fear people have at rest immediately at once.
Thank you.
Yeah. You see, first of all, the National Democratic Congress in its 2024 campaign manifesto, which is the social contract we had with the people of this country, overwhelmingly endorsed at the poll, was the fact that we promised that we would put in place a proper mechanism for the establishment of the public tribunals. Consistent with the promise H.E. John Dramani Mahama made to the people of this country, steps have been taken to establish that. Fears have been raised. I've listened to my learned senior Abu Jinapo, and I've listened to Ambassador Michael Quay now. Those fears are without any basis whatsoever.
Why do you say so?
Legitimately, you can describe them as red herrings. No basis. Look, I have with me, and because you gave me the topic, prior to coming here, I went for the public tribunal bill. So as to inform the public adequately on what the government intends to do. Let nobody put any information misleading here.
Thank you.
The tribunals are part of the 1992 Constitution.
Thank you.
And there had not been any amendment whatsoever till now.
That's true.
In fact, the only time we came close to anything like an amendment was what happened in 2002. That is the Courts Amendment Act 2002, which amended the Courts Act with the removal of the district tribunal only. And that was even in 2002. But the regional tribunal, as established by the 1992 Constitution itself, is still there in our books. The only thing that was lacking is how they will operate. It is that operational mechanism that this bill is seeking to fill and to intervene. And so if you look at the bill, and before the bill, look, like I pointed out, Yebi and Abalifo was tried at the regional tribunal here in Accra. Incidentally, the respected senior state attorney, Anthony Jambibi, he prosecuted that case. And my senior in Krabia Fadate was the lawyer for the accused persons at that time. That was when the NDC reported its missing money. And the matter went to the court. And incidentally, in that case, if you recall, Senior Nkrabia Efadate raised an issue about its jurisdiction, which the Supreme Court had the opportunity to consider. And the court, the Supreme Court at that time, yes, referenced that the regional tribunals, yes, in fact, had jurisdiction to try those serious offenses, even though the money stolen belonged to the NDC. So that record ought to be set. Look, there in the Republic, even robbery were being tried at that time by the public tribunal. Now let's go back to the fears expressed by Marlene Senior. If you look at the public tribunal, the bill itself as we have it, and I want us to go to the proposed section 11.
Section 11?
Yes, okay. Of the bill as proposed.
Section 11
of the proposed. No, this one is the proposed.
Yes, the proposed bill. Yes,
this is the proposed bill.
I just put it all together. Yes, I'll send it to you.
Section 11 of the
2026 Tribunals bill.
Yes. So, Senior.
Do you have it now?
Yes,
I'm talking about Michael Kwe Jr. Do you have it now?
Maybe no, I can share with.
Well, we're ready.
I can share with him. Okay. So let me just proceed.
In fact, please,
yes.
Go ahead. Yes.
Section 11 of the proposed bill. And just to ensure that everything confirms with the 1992 Constitution, this is what it says. Appointment of chairman of public tribunal and panel members. The fear he expressed relative to the panel members. And see what the bill says. 11.1. The president shall, acting on the advice of the Judicial Council, appoint the chairman of the public tribunal. B, the chairman of the district tribunal. So it is upon the advice of the Judicial Council.
So it's not the president.
It's not a whimsical, capricious. And in fact, this provision is the same as the appointment of high court judges. They basically lifted it verbatim with all the necessary modifications. Now, what happens to the other members, the other panel members, the appointment? That's 11.2. It said the Chief Justice shall, acting in consultation with the Regional Coordinating Council for a region and on the advice of the Judicial Council, appoint panel members of the Regional Tribunal. So where is the fear? Important constitutional safeguards. So the other members of the District Regional Tribunal are going to be appointed through the Chief Justice, having consulted the Coordinating Council of the respective region. That's for the Regional Tribunal. On the advice of the Judicial Council. Fair safeguard. Now for the District Tribunal, the panel members, the same 11.2 now says that when it comes to the District Tribunal panel members, one, the Chief Justice must consult the District Assembly on the advice of the Judicial Council. Just as High Court judges are appointed, Circuit Court judges are appointed. The same procedure had been what? Brought into this public trial. So the fear that maybe some NDC member working somewhere can be picked and put on the public tribunal, that fear is cured in the proposed bill. In this country, NDC, NPP have had even non-party members appointed to the apex courts, superior court judges, and they have delivered justice. That had never been a problem.
Because there are guidelines.
Guidelines. You can't act whimsical.
The law is the law.
Well, no. The last time that phrase was used, it became problematic. No. I would restrain myself. So let me just stick to the issues. So, Section 11 of the proposed bill, which deals with appointments to the regional and district tribunals, have provided enough constitutional safeguards against such whimsical and capricious application of the rules just to undermine. When I listened to my learned senior Abujinapo, it became obvious that as at the time he was speaking, he's not had the benefit of reading the bill. Because if he had the benefit of reading the bill, those concerns would not be raised. What are the fears? He, Abu, at the time he was MP for Damongo, at the time when he was Deputy Chief of Staff to President Addo Dankwa Akufo-Addo, the President appointed a non-NPP person as a Superior Court judge. Was it legitimate? You had confidence.
But you want us to
Please,
remind you of your
No, I'm coming. I'm coming.
Don't go there.
No, the point I'm making is that, so what is the fear? What is the foundation of that fear? If you go back to the bill, it tells you, and I've spent the whole night combing through the bill just to ensure that we allay the fear of the public. Now, the innovations that I see in this bill, and Senior Martin, with your guidance, if you look, I have some challenges why those particular offenses have been listed. Look, code of conduct and disciplinary rules. A member of the tribunal is subject to the relevant code of conduct and any other disciplinary rules, just to ensure that they don't misconduct themselves. It's here, Section 14 of the proposed bill. Now, what is even interesting is that the innovations in this particular bill, and for me, the thinking outside the box, is that it says that when this public tribunal is trying a matter, okay, which involves specific, and the law is specific. It says that when it involves minerals and mining, this is how the tribunal should conduct its affairs. Profound. We don't have any such law so far. It says that when you are dealing with galamsey-related offense, and this is President Mahama's commitment to the fight against galamsey, he said there shall be no stay of proceedings. It's in the law. Look.
Yeah, but
I'm coming, Senior. I'm coming.
The challenge. You
See, Session, no, Senior. No, you say Senior. In one breath, please. Mode of trial. And then right to legal representation. It says, Section 27(1), a person who appeared before the tribunal shall have the right to be represented by a legal counsel chosen by the person. Safeguard, fair trial, Article 19. Here. Application of Evidence Act. The Evidence Act 1975, NRCD 323, applies to proceedings of a tribunal subject to necessary modification. Further rules of engagement. The tribunal may admit evidence whilst ensuring compliance with constitutional and statutory safeguards. Constitutional and
implied.
No, I'm even saying that beyond even the implication, this one is expressly provided for. Further safeguards. Now, another interesting one. Live broadcast of public interest cases before the regional tribunal. Live broadcast.
That is
Section 31. It says, proceeding before the regional tribunal which involves a matter of public interest, including an offense against the state, may be broadcast live. So so that if the tribunal members are misconducting themselves, the whole world will see. No secrecy. You can't go and hide.
The courts too
No. But I'm saying that. So what is the fear?
If at
the end of the day, the whole public will see their conduct. No secrecy.
When the law says may, it is not obligatory.
But I'm saying that. You even want to share. Very well.
Because of the experience I have.
Very well.
It must be
That's even good. Now, let me, I beg you. This one is important for me.
We'll take a quick one from the president. We understand the president has just arrived in Addo.
Okay.
I think, yes. For the second.
He's the boss.
He's talking about the vultures again.
He's the boss.
Let's cross over now. Komla Kluche is with the president. Komla, tell us what's happening where you are, quickly. Yes. Please.
Deployment of the trucks, the dump trucks, has just started, just like His Excellency the President said yesterday. They were going to retool the task force led by the military to do the cutting of the debris and the silt. Quite a huge number of them. We've counted close to about 15 trucks that have come here at the Alajo Enclave where he was yesterday. And the desilting and the clearing of the debris is ongoing. You can see right in your shot we have the tipper trucks all over there. And then the loaders also as well. But I mean, I can tell you the amount of filth, stench, most especially that has engulfed the area, cannot be underestimated. It tells you the enormity of what the challenge is. The issue about cholera and all others have also come to play, especially the caution being sent to the public. But let me just try a bit and then engage the Minister for Local Government now, who there are some questions that we may have to put to him regarding where all this filth will be sent to. Good morning,
All
Honorable.
right, so my colleague Komla Kluche is there for us. We understand the president is arriving shortly. When he does, we would cross over to him right now. Yes, but this is just our coverage of the day 2 of this nationwide sanitation day. We're still live here on Key Point on TV3. We're live on 3FM 92.7.
Let me be on record. I'm saying that I rather will use the word shall to make it obligatory on us rather than may, which presumes that it may be done or may not be done.
Okay.
Because the public hearing is very important. Because these are.
And I strongly agree with him, so that at least the whole public knows what's going on. No kululu, no libilibi, no labalaba. The other point is that if you look at session, and look, Alfred, I beg you, I'm taking small time because this thing is important that we clear the public conception about the public tribunal because of the misinformation that has been put out. With respect, if you look,
you have your time.
It says defense of accused person and preliminary objection. Just to ensure expeditious trial, it says that a person who wants to oppose a charge shall, within 10 days, so limited time, when the charge sheet is served on you and you have an opposition to it, within 10 days you must file it.
Okay.
What this bill is introducing is speedy trial. So the point where lawyers can deploy all our skills, wait, and do, we want to cure it with this one. Now, even more profound is the minerals and mining processes. It says where a party to a proceeding in relation to a matter under the Minerals and Mining Act 2006 is dissatisfied with the decision of a tribunal in respect of an interlocutory application, a party to the proceeding may make an interlocutory appeal against the decision of the tribunal. During the trial, interlocutory appeal shall only be made after the conclusion of the case. So where, for instance, tendering of evidence, you have an objection, you want to appeal, you want to stay. It said those things you can't do it with the public tribunal.
You have to finish the trial.
You have to finish the trial. Then if you have interlocutory appeal, you consolidate all of them and you do it. That is not what is happening with the current legal regime in criminal trial. Because at this...
Because I have an appeal that has not been set in 4 months.
And I remember, and I'll tell you, when I did the NCA...
The wheels of justice grind slowly.
No, but I recall when I was doing the NCA matter, we tendered in evidence. and we raised an objection with it. So that objection was overruled, and I appealed it. And I brought a stay application before the Court of Appeal, Kuram, Tanko, blah, 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 at that time. They said, look, yes, it's a legitimate basis for an appeal. However, the stay will be refused. This time around, the legislation is trying to cure that whole enterprise where you can only file the interlocutory appeal when the prosecution says we have closed our case, then you can do that.
Also come with time for them to determine the appeal. Because, and again,
no, so is
when
there,
the appeal has not been determined,
yes,
there must be a stay so that...
listen. Section 39(3) of the proposed bill says that an interlocutory appeal filed under subsection 1 shall be determined within 30 days.
And shall operate as a stay.
This one, it does not. Now, it says that, section 40, stay of proceedings. There shall be no stay of proceedings in the case under the Minerals and Mining Act 2006. So when it is a galamsey-related offense, and the public tribunal is doing it, it says that there shall be no stay.
So how fair is that?
But you see, this is a determination to ensure that criminal justice is administered speedily.
Yes, but again...
These are not legitimate. So I am saying that this bill introduces very innovative provisions to ensure that the things that we lawyers do, basically, you know, there will be a certain... There will be a certain...
Thank you. So let me just make this one. I mentioned here that he was talking about galamsey. And you remember I said one of the things... One second, I need to make
No, I'll come back to you.
The tribunals are trying to make a galamsey case. It shouldn't be the case.
Okay, thank you.
And secondly, if we look at this issue of...
You are not on. Listen, I'll come to you.
To look at this 15 days, 10 days matter. Just quickly. We want to understand
my good friend's submissions. Indeed, it is important for us to also look at how we stay proceedings when you have filed an appeal. I have already now an appeal at the Court of Appeal that is 4 months, and the Court of Appeal, they have not even settled the records. And in that case, if the proceedings are going, it renders the appeal nugatory because it cannot affect the proceedings. By the time we come back, it would have finished. So much as we want to expedite the trial, let us also make sure that appeals as raised at the end of the close of proceedings of the prosecution be also given time arrangement so that we will come back quickly and then continue. And the clause that says, or the section that says there shall not be a stay, it's defeating the purpose of the appeal. So we should look at that one. Nevertheless, let me go on with my submission.
Understand you MPs, when the thing is still at this level,
yes,
you
so
call it clause by clause, not section. So for now, let's... my former colleagues to look into this matter, do the necessary debate and make sure that the right things are done. But on my own, let me, my contribution this morning on the bill. Indeed, I'm going to speak as a lawyer without more. So... we go to Article 126 of the Constitution.
126.
126 of the Constitution.
126(1).
126(1).
The judiciary shall consist of...
And for purpose of time, let's go to 126(1)A(I). So the judiciary shall consist of...
The High Court and regional tribunals.
Shall, and the word there is shall. Mandatory. So that... it is the word tribunal that is agitating all of us. But again, in our constitution, it is so provided that it shall. So it is even late in time. Because the constitution having given us this order, we ought to have done it even before now.
It was there. We just stopped using them.
But you see, I'll come back to that.
No.
I'll come back to that.
You know, the 2002 legislation actually... proscribe it.
No, the regional tribunal.
No, that one there was never. It was the district.
And you go to Article 143. A regional tribunal shall have jurisdiction to try such offences against the state and public interest as Parliament may by law prescribe. So the expectation is that Parliament will bring out another law that will guide the performance of the regional tribunals. And in fact, the regional tribunals are given specific roles, not general jurisdiction as pertains in the district court
specific.
or the regional courts, but by the constitution is given a specific assignment, and that is why maybe reference is being made to trials under minerals and mining law.
And in fact, that's Section 11 that Lawyer Digitamaklo read in this particular bill.
Yes.
Clause 11.
That's Clause 11.
Yes.
Is captured in Article 1443.
Yes.
Justices of the Court of Appeal and of the High Court and chairmen of regional tribunals shall be appointed by the President, acting on the advice of the Judicial Council.
So that is not even going
to reproduce.
But let's look at the constitutional provisions. And again, Article 143 says that regional tribunals shall have jurisdiction. And you see, when the Constitution or the law says shall, it means it is foreclosed that it must happen. So for me, the matters of its establishment is a constitutional matter. Whether or not we like it as a state or as citizens or as Ghanaians, we may have to, then repeal those clauses of the Constitution, amend by way of amendment, amend the Constitution. But again, don't let us also forget that these are entrenched provisions, that it cannot be amended as of right of Parliament or any institution. It must be by referendum. Absolutely. You see, so if we want to amend a constitution as it speaks like this, then we must go through the process of amendment, and then we take it out. But not until that time. The constitution is ensuring that we do it. So if we want to do it now, I don't think that, for me, it is not unlawful. But if we are not happy with the situation, then we must go through the process of changing the provisions on the law. But given this opportunity to affect the legal system through the Constitution, let's look at Article 139 2D. And it says that the court shall consist of
139
The High Court shall be constituted by 3 judges of the court for the trial of offences of high treason or treason as required by Article 19 of the Constitution. So it says that the High Court can try treason and high treason. Now go to Article 143. The High Court shall have no power in a trial for the offence of high treason or treason to convict a person. You see, the same Constitution contradicting itself.
So what's the point?
You understand? So what I'm saying is that these two laws are contradicting to each other. And therefore, in the hierarchy of norms, when there is a provision that comes against another provision in the same law, the import is that the first one gives way to the second one.
Because the whole idea is that the legislator knew of that before introducing.
Yes. So the first one will give
more or less to cure a mischief earlier.
So I am saying that this constitution, as you have it, has these two provisions contradicting each other, and for which reason it retires Article 1392D as non-effective.
All right.
And therefore we will go away with that. Now, coming back to the tribunal system and the fears as expressed.
And the fears, yes.
The fears regional tribunal. Yes. Because it's a constitutional expectation, we cannot fault it. But that is why there's a requirement of Parliament passing a law to effectuate the provisions under the Constitution. So Parliament has a duty to ensure that all the safeguards that will cure the fears of the public, and in this case, minority, make sure that these provisions are provided to cure.
And I think that they are already there.
But like I'm saying, no. It will be subject to debate. Listen, it will be subject to debate. But as Martin said, they are not sections of the law. There is only a bill there. So these clauses are only clauses to be debated in Parliament. So I will urge all of us to follow the debate critically, particularly members on the Constitutional and Legal Affairs Committee. They must show presence and do the debate. And again, when it comes to the plenary, the minority will have various issues with various clauses must be there and debate it and make sure.
But even before this bill is passed by Parliament, that fear of government or the NDC appointing its people on the panel to, as it were, prosecute opponents. Is that fear not addressed already in the Constitution?
Well, they are not law yet.
No, I'm talking about
so
the Constitution.
So you could still have the fear.
No, I'm talking about the Constitution.
Okay.
Because if you read 1252, it says citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor system. 1443 says, 1444 says, panel members of regional tribunals other than the chairman shall be appointed by the Chief Justice in consultation with the Regional Coordinating Council for the region and on the advice of the Judicial Council.
Yes, so the provision is there already. So this is the provision that is being lifted into the new act.
So is there any basis for the fear that only NDC people will be appointed on the panel?
Oh, well,
based on this particular provision I just gave?
You see, unfortunately, sometimes when we start the debate without having gone through the existing provisions, because some of these acts, the sections in the act are provisions in another law having been lifted and positioned there. So if we are not challenging the existence of these provisions in this superior law, where is our mandate to challenge it in the lower law? The act is a lower law to this.
Thank you.
So what I'm suggesting is that let's go in there, do the necessary debate, make sure the right things are done. But the institutions that are going to be created by this new law, let us see also that these institutions work to perfection.
Thank you.